This is a part first appeal in the matter of EasyGroup Ltd versus EasyFundraising Ltd and others.
May it please, my lords, the same counsel who appeared before you yesterday, just in case.
Put everybody off.
I was proposing to reply to a few points given by response to my friends yesterday, impressionistically, but I'll try and keep them in more or less the same order in which they took place. So the first issue that we wanted to respond to, and I hope not to say very much about it, is the airline passengers point. Now for that, we say simply that defining the specification by reference to the public is obviously, we say, the wrong way to go about it. My learned friend has come up with a proposed revised specification, retail services in connection with the transportation of passengers by air. That has the merit of adopting language that is recommended by both the IPO and the European Court when it came to retail services, partly in the sense that it says retail services in connection with. That, there's nothing wrong with those words, but it's the fact that it's limited to the transportation of passengers by air. Retail services specifications generally focus on the nature of the goods or services being retailed, and this is very clear from the Practica Bow case, which was the first and most important case. It's in your bundle of authorities. Tab 7.
Just before we get into the detail, do I take it from what you've said so far that you're not opposing the amendment to the respondent's notice? The amendment to the respondent's notice in this regard. Yes.
We are opposing it. Yes.
No. There's two separate questions. One, can they argue it? Two, is it right? And you've been addressing the merits,
yes,
which presupposes that they can argue it.
Yes, but we don't have any difficulty with
it.
Or it might be said that they shouldn't be allowed to amend because it so lacks in merit, but that's another issue. My lords want to hear it. It's easier.
You're not opposing it on procedural grounds.
I'm not opposing it on procedural grounds. There's always a certain amount of tinkering that goes on in these situations, and we have to just live with it, as my lord knows from other cases. The retail services, the problem with this, of course, is that it doesn't match the Practica Bow guidance. Tab 7 of bundle 1 of your authorities. And this was the sort of first and most important of the retail services cases. The other one was the Netto Market case.
Which paragraph?
So I wanted to just first of all introduce what was going on here. This was a reference from the German Patent and Trademark Office concerning the registrability of a retail services specification.
Well, we looked at this case in the first appeal.
Exactly, I saw that on the video, so I wasn't going to spend too much time on the facts. The particular paragraphs in question, the first most important one is paragraph 34. Before that, they say that it falls to the court to supply a uniform interpretation of these services. And they say, 34, it should be noted that the objective of retail trade is the sale of goods to consumers. That trade includes, in addition to the legal sales transaction, all activity carried out by the trader for the purposes of encouraging the conclusion of such a transaction. And that activity consists inter alia in selecting an assortment of goods offered for sale and offering a variety of services aimed at inducing the consumer to conclude the transaction. And that's important because of what they then say at paragraphs 44 to 50, which I'll ask you please to read. With particular emphasis on 49 and 50.
Yeah.
So the guidance is the retail for a retail services mark, certainly at the point of registration, the part that needs to be really defined and specific and comprehensible are the are the goods that follow the nature of the service, because the applicant must be required to specify the goods or types of goods to which those services relate by way of, for example, particulars as those contained in the application for registration filed in the main proceeding. What that means is you can have a mark for bringing together for the benefit of others sporting goods, or the same language in relation to fine wines or clothing, whatever it might be. And that is that's the important part of a retail services specification, the part that distinguishes it from other retail services specifications. What they don't say is that you need to dwell too much on the particular type of retail service, or the, let's say, the framework in which that retail service is provided. And that, we say, is obviously the point that only applies at registration, and different considerations might be said to come into it later, but it's a very clear steer that where these sorts of marks are likely to be narrowed, it's going to be in relation to the things that are being retailed. And just for your note, we don't need to turn it up, the Netto Merkin case, which is about retailing of services, says the same thing. So you must define the services with clarity that you're going to be retailing. If you're a price comparison site or you're an EasyFundraising site, you must define the services, but the actual type of retail you're doing, whether it's online, offline, whether it's bricks and mortar, whether it's in flight or whatever, we say that is not likely to be a material consideration once you've identified the true purpose of the service.
Is there any case that has considered the question in a context similar to this? Because this is quite a special circumstance where they're only providing goods on plane.
No, but all of that I'm aware of, not that I'm aware of, but all retail services will be provided in a particular environment. So they'll be in a shopping mall, or they could be a sporting goods shop. Because don't forget, it's not just simply collections of shops, it's collections of things, collections of goods. Any retailer, if you walk down the nearest street from the court, is going to be potentially providing a retail service. So we say that way madness lies, in a sense, because you're getting too pernickety at that point to start thinking about trying to define it by reference to the sector. The other point I would say about that is, you'll recall from the Ferrari case that there was an attempt to define motor vehicles or land-based vehicles by reference to the market sector, upmarket or expensive cars and that sort of thing. And that failed for the same reason. You don't normally look at the sort of commercial sector in order to define the goods. Well, it depends on the goods and services, of course, but retail services, we say you don't.
Distinction in the real world might be between those that only sell online and those that sell through bricks and mortar stores. Is that a distinction that's ever been relied on?
One could well see that as a sort of meaningful thing, but it depends. I mean, and actually this case gives a good example as to why that's not a distinguishing criterion, because we sell to people physically and we sell online. So, you can pre-order.
Well, the delivery isn't online.
The delivery is physical. No,
It's
exactly.
never on.
So, and then there's a distinction between whether I think Mrs. Justice Bacon made a distinction between home delivery shop and one where you're delivered the goods on the plane. I mean, okay, yes, that is a distinction, but the question is whether it's a meaningful one in terms of the specification. And once again, I just briefly emphasise a point that I emphasised yesterday, which is that it's not right. When you talk about fairness, it's one of those words that everybody thinks their view is fair. But fairness must surely give the trademark proprietor the same rights to the market as everybody else that it's actually competing with. So if you look at who it is competing with, airline passengers, it's competing with a large number of other retail services for that custom. And it's only fair that it not be restricted in that endeavour. We then, another point on, and it is a bit impressionistic. The next point I was going to address was the respondent's notice in relation to the quantity of email services provided under the easy.com mark. Is that right?
Yeah.
Yes, easy.com. For that, we say the first point is that the learned friend made a general complaint about lack of evidence. Now, the respondent's notice is restricted to the lack of evidence of the number of email accounts. So it isn't a chance for her to do as
Well,
applicants.
if you're making a point like that, which is maybe a perfectly valid point, we need to have a look at it so that we can see exactly what it
Yeah.
says.
So the respondent's notice. Tab 5 of the quiz. Yeah. That's right, yes. The judge, it's paragraph 2. The judge should have held that the easy.com mark had been
So page.
page 30, paragraph 2.
For the additional and independent reason that there was no evidence before the court of the number of active email accounts during the relevant period.
I'm not saying that's not a viable respondent's notice. What I'm saying is that it really is, at this point, it's not open to my learned friends to start complaining about lack of advertising and other evidence that could have been called. They cross-examined the witness in relation to this, and Mr. Anderson, and obviously had the chance to put points that they could have been. And more importantly, the judge here noted.
Sorry, can I just be clear? We were told by Ms. Hemsworth that the only evidence was in the relevant paragraph of Mr. Anderson's written statement.
That is right.
And you say, it's obviously correct, that they had the opportunity to cross-examine, but was he asked any questions about that paragraph?
No. Was he asked a question about that paragraph? That I can't answer. But he was not.
You're not relying upon any answers in cross-examination as supplementing his evidence. Can I put it like that?
No, I just say that in his evidence he referred to these email services being provided, and that wasn't challenged. And indeed, the judge himself held, in this case, of which there was no evidence of quantity. He specifically said that in that finding in the judgment. I'll just get you a reference. I think I took it to you yesterday. But it's paragraph 149. So it's not as if it's completely out of view. He said, the question raised by the defendant's challenge is whether this use, as to which no evidence of quantity was given, was merely promotional.
I'm trailing behind you. Can you
Sorry,
give me the reference?
page 139,
Yeah.
tab 10, and paragraph 149.
Yeah.
So we've got a situation where the point is in play, but it's sort of being acknowledged that there was sufficient use for the purposes of ascertaining whether it was merely promotional. There's no caveating or reservation of that position. And it was simply noted that there was no evidence of quantity given. So now it is said, well, the judge should have taken that and plugged it into his findings in this section as an additional reason. I mean, it's a poor additional reason for the following reasons. With every revocation case, the evidence is always different. There's evidence sometimes of invoices, of advertising, you've got live evidence, you'll have physical evidence, you may have photographs of the product, and it's a sort of mosaic. And what happens is, the party will frequently not have, for example, very clear evidence of the dates, and you need to make inferences as to when that happened. What we know from Mr. Anderson's evidence is that there was 20 years use, of which I think 3 or 2 years was in the relevant period. There was 20 years of use, and we saw it at the top of the EasyGroup website. Now, yes, we don't know the exact numbers, but one can infer that there was sufficient use for the purposes of volume to make the assessment about whether it was genuine. Now, and that is why, no doubt, the defendants took the course of arguing that it was purely promotional. Now, let me address the promotional point one last time, because it seems that it actually boils down to a very simple point, which is that Silberkel simply does not apply. Without turning it up, Silberkel was a case where the drinks were given away at the point of transacting for other goods. So it was a giveaway at the point of transaction. That is not this case. In that case, there was never any attempt to make a commercial, or to enter into a commercial transaction in relation to the drinks. Here, the email services were distributed first. They weren't given away with something else. They were simply given, and they worked. People sent and received emails. And that's not, it's simply not the facts of Silvergirl. And then the question is, oh, but if it has a value in cross-selling other goods, getting people to visit the site, basically, that is somehow illegitimate. That can't be right in the light of sort of the role of that sort of product, service rather, in the economy. Email services are frequently provided free at the point of use for the purposes of getting people to, you become the product with Gmail, perhaps that's the way of putting it. You are the commercial product, or there is an economic value in transacting with other aspects of the legal portfolio, such as YouTube. So we say that the attacks on this were actually detached from reality, because the reality was there wasn't a genuine email service happening. It did use the distinctive identifier, and there should have been no narrowing and certainly no total revocation as there was in this case. Now, immaterial variance. Let me deal first, please, with the amendment issue. Unfortunately, it was an oversight that we did not specifically refer to that particular variant. And the question is whether the court, first of all, should allow us to amend, and secondly, if we do amend, does it make a difference? So, should it allow us to amend, we say that the amendment is important. It's not existential, but it is important depending on the court's appraisal of the various tick ball variants and other variants. If the court is of the view that the composite tick ball variants are all just uses of an Easy Life word with either a separate mark, which is the logo, or a bit of immaterial or unimportant stylization, it may not matter, because we don't need the tick ball variant, because we say that the tick ball variant, the tick ball lifestyle variant, which is the one that was used for advertising services, contains within it the text, and it also contains one of the other tick ball variants, variant A. So we get to the root, we get to the same conclusion by a different route. If the court's against us on that and considers that the mark to comprise a sort of composite mark that we should have really been focusing on, that then brings in obviously the analysis becomes a balance between, is it important to us compared to the prejudice that the defendants say they would suffer if it was allowed in. Ascertaining the prejudice that the defendants would suffer has been a circuitous and difficult exercise, to put it mildly. My learned friend started by saying that they would have put in issue, or they would have attacked the factual findings of the judge concerning the use of the tick ball lifestyle variant. Now, leaving aside that itself is a difficult thing to do, challenging factual findings, we never heard exactly how it was said to be flawed, other than the legal characterization of the use. But more importantly, after some initial lack of clarity on the point, my learned friend confirmed that the factual finding in your other case was the same. Now, it wasn't attacked there, and it really mattered there because they lost on whether that was an immaterial variant. So, as a result of that, you would have thought that if there was a genuine attack to be made on the factual finding of that variant regarding those services, given that it is identical in both sets of proceedings, one would have thought they would have already attacked factual finding in those proceedings. The final point is that, of course, in terms of ascertaining the prejudice to the defendants, they are resisting the partial revocation, so that they are contending for and defending the partial revocation of those services, a point which doesn't arise if it's never been used in relation to advertising services. And so they haven't been prejudiced. They've got the full weight of that point available to them. The only point in which they're prejudiced is an apparently, we say, unspecified attack on a factual finding of the judge in this case, where they didn't attack the same factual finding by a different judge in another case. Now, I don't have full visibility, as my learned friend has the luxury of all the points that could have been made, but we've got to deal with what is said. And in court, it wasn't clear from our perspective how they're able to achieve a consistent position by, in principle, wishing to attack the finding here, but not in those proceedings. At least, from my perspective, it was not clear. Now, coming to the point of substance on immaterial variance, my learned friend was keen to point out that the judge used the word distinctive several times in his judgment when he was appraising the appearance of the variant use and comparing that with the registered form. But there's a problem upstream of that, which was the problem I identified at the outset of my submissions yesterday, which is that the judge never asked himself what he was looking for and what he meant by distinctive. Distinctive is one of those words that takes quite a lot of colour from its context. This was not a case about distinctiveness, Jen. There wasn't an invalidity attack based on descriptiveness and so on. So the point wasn't really uppermost in the court's mind. And that's why I was keen to point out that distinctiveness has a very specific meaning under Section 46 that is similar to the meaning under Section 3. Distinctiveness in this context means one thing only: the ability of that element to contribute significantly or at all to the ability of the mark as a whole to indicate trade origin. That is it, nothing else, nothing less will do, and that must be present. The judge never defined distinctiveness, never asked himself what distinctive meant, and when you look at key paragraphs in the reasoning, it comes across that the judge is sort of using distinctive in the sense that you might say, he has a rather distinctive look. His clothing is rather distinctive, or whatever. She has a rather distinctive voice. Standing out, being striking, having eye appeal, being attractive, decorative, having a different design. Those are all not answering the fundamental question. In all of these cases, all of them, the ones that were decided in favour of immaterial variant, the design is very different. It's strikingly different. In Specsavers, probably the most striking one of all, it could not be said that the device of the two semicircles did not alter in appearance when you have the word Specsavers written over the front. Of course it did. But the question is whether, in all of these cases, what is done alters the distinctive form of the mark as registered.
Now, on that point, you mentioned in the context of dealing with amendment a point, which I have raised in the course of argument, but up until this point, didn't seem to have been clearly articulated on your side, which is how one views the so-called tick or variance. And so you suggested that they should be viewed as two signs.
Effectively, yes.
In effect.
The problem is a little bit hamstrung by the lack of authorities in the bundle and not wishing to inundate the court with more. But it is well established in law that when you have, there's no requirement to use a mark alongside another mark. So there's no requirement in order to show use that it be used on its own. So once you establish that, and so if the, for example, I think I gave the example of a wine bottle. If you have the label, the name of the wine, and then you have other language underneath it, the question is always, do you take a sort of snapshot of the whole label and then compare that to the registered mark or not? And the case law very early on established, well, of course you don't, because those are separate signs with separate functions. When it comes to the issue of the tick ball, this is why it's completely beside the point that the tick ball was said to be prominent, used a lot, to have visual significance, to be large, to be attractive, whatever. It doesn't matter because it's not present in the registered mark, and it has a separate significance from the registered mark. And when I say that, I mean the consumer won't pronounce the tick ball. It has a different semantic value. It has a principally visual value, and it has a separate role. It's very common in Shell oil or Starbucks coffee that you have a picture and you have a word. And they have a separate significance. The fact that traders may register them sometimes together is a different point. But in fact, here, they weren't registered together. We're not dealing with a registration with the tick ball. What we're dealing with is use. And so you must ask yourself, that use which contains the tick ball, is that use of the mark in the form as registered? And we say it is so, or in a manner which doesn't alter the distinctive character of the mark. It's a distraction. My lord, does that articulate our case more clearly? Or
Yes, thank you.
the point about the judge's analysis of this was that he was, we say, unduly focused on merely visual significance. And my learned friend, Mr. Akins, also seemed to support that view. He said the statute says alteration, alter the distinctive character. That means any alteration, and qualitative or quantitative. My submission, that is not a realistic approach in the light of the case law, because on that basis, all of the cases would have been decided against the proprietor. It isn't about alteration in a strict sense of any alteration. It's alteration of distinctive character. And there are various things that can happen, various elements added and taken away, which do not alter the ability of that mark, modest though it may be, to indicate the distinctive character, indicate the origin. I mean, the assessment of the judge throughout the judgment used design, the words design, decoration, put these in our skeleton, I probably don't need to. So the judge did, for example, if one looks at the judgment page 140 of tab 10, paragraphs 155 and 156.
So paragraph?
Paragraphs 155 and 156. We have a sort of cascade of adjectives, but what we don't have is any indication of what the court is looking for. But in 156, for example, the distinctive character of the mark is partly in the conjoined word easy life and partly in the design with strapline and decorative elements added. So that would tend to suggest, reading that he thinks, forget then the individual elements, it's the overall design. The word easy life is weakly distinctive, and then he says it's descriptive, but the word is not strongly distinctive. Such greater distinctiveness as the mark has is attributable to the design elements. Well, that there does not explain how that could be. It doesn't explain how a little a triangle or a barely legible strapline, which the judge has described as strapline, is contributes to its ability to indicate origin over other words or other marks. And that's really the essential problem, we say, with it. The judge does use the word distinctive, but it isn't clear that he's asking himself. In fact, we say it's clear that he's not. He never defines it and never explains that the target is to ask himself, will this mark be registrable for exactly the same reasons in the form on the register as it is in these other variants? I think the tick ball has a particular purpose. I think we can put that to one side because it's simply a separate sign, we say. Then you're left with the absence of a little abstract symbol where the dot should be, and a varying
It's
strap
not an
line.
abstract symbol, is it?
But I think
It's a tick.
well, it could be a tick, yes.
I mean, you just made a point that strap line was barely legible.
Yeah.
That's because of how it's showing here. If you look at that mark properly printed out,
Yeah.
you can read the strap line very easily, and you can make the tick out very clearly.
Yes. Well, in my learned friend's skeleton, she. The reason I said that was because I wasn't sure that you could, even when it was blown up, whether it was clear as a tick. But even if it were a tick, my lord, the point is this.
That helps you in one
I was
sense.
going to say.
It's sort of a descriptive thing. And when
So
it
it
comes
does.
to the
I was
strap,
just jibbing at
Oh,
your
right, okay.
dismissal of the point because I didn't think it was right or fair.
I think some people see a tick and some don't in this one. The other
I
thing
saw
about,
a tick.
the other thing about the strap line is, of course, it's one of the things immediately notice is it's varying, because of course the function of a strap line is simply to have a little bit of blurb under the mark. That's why there's things like lifestyle variants, solutions variants, and so on. Those are very unlikely to contribute anything at all. So, I mean, just to make one last point on this, I mean, it's the conclusory paragraphs 162 to 164 where you would expect there to be a clear analysis of the ability of those aspects to indicate origin. And the example given in our skeleton of shopping brings into focus what we're talking about. Because it strips away the word. Imagine the word was completely descriptive. Are these elements able to do the lifting, the heavy lifting of being distinctive? And it's not clear.
Well, you made that point.
Yeah,
you know.
yeah, exactly. So, the next point was I addressed you on prejudice. I wasn't going to say more on that. The next point then is my learned friend Ms. Himsworth about when she was analysing the points of similarity between the Easy Life retail services specification and what Easy Funding do. This is quite an important.
Sorry, can you remind us which ground is this?
This is our ground on infringement, which is yeah. This is I think the first ground was 5. Let me just check this round. Okay, I'll get one moment. It may have something to do with a few of them, that's what I was saying. This is it's the ground 5. It's ground 5 because it's infringement of the second Easy Life mark, which has the very long retail services specification. So it's got retail services, and then it's got very, very long lists of goods. And my learned friend was pointing out all of those things are goods, and that was said to be a very important point. Now on that, we say that doesn't really help learned friend, because the service that's being provided by Easy Funding is not goods, as they have been at pains to point out. We have a retail services specification for goods. They have a retail business offering to the consumer retailing of services. Now, they also offer, the underlying businesses themselves offer services and goods. So if you imagine the chain is Easy Fundraising are offering a retail service of bringing together for the benefit of others, other services. So they are strictly providing a retail service of services, the netto market type scenario. Then the people that they are bringing, the entities that they are bringing together are themselves a very long list of people offering both services, in the case of travel, for example, hotels and flights, but many other services, such as John Lewis, who offer everything from home insurance to men's clothing. So they're offering services and goods. So the point is really that we have a very, very nearly identical, but not quite, retail service being provided here by EasyFundraising. And it was significant that my learned friend was really unable to articulate a definition for what service is provided to the consumer. The judge focused on the service that is provided to the traders. And we agree, that's an advertising service in relation to the traders. And we have difficulties with that because, of course, we're left with a much more sophisticated, careful, educated consumer who knows who they're dealing with. From the consumer's perspective, something is being provided. I subscribe, I sign up to the EasyFundraising service. I know that the EasyFundraising service will contain a complete list of all the traders who are going to donate to my good causes. That is what I'm getting for my extra 15% or whatever it is that I pay. I don't know how much they pay on the goods. They may pay the same price. The point is, the service, how do EasyFundraising make their money? They make their money by taking half of the, I think it is 50% of the commission that is coming from the retailer. But that doesn't mean that they're not providing a service to the consumer. The consumer is a classic retail service of services. There are other examples in the modern economy, such as price comparison sites, aggregation sites. My learned friend sought manfully to defend this on the basis that it was just a listing service. But listing is fundamental to a retail service of services. That's pretty much what it does. All the businesses that satisfy the criteria of offering competitive car insurance, here you are. Can you transact with money supermarkets? No, I don't believe actually we can. I don't know if it's a good example or not. It doesn't matter whether you can transact with EasyFundraising. The point is the service, the added extra, is precisely the bringing together. Here are all of the good retail services that you can trade with. The fact you go through an interstitial page is immaterial. There is a value in having them all there. That is how EasyFunding gets its business.
That submission you made yesterday.
Yes.
These are your submissions in reply.
I probably completed it so far as the just responding to that point. But yes, I apologise. I'll move on. We on the same point of infringement, and this actually applies to all of the grounds of infringement. There was the usual argument that it's just an ordinary descriptive word, easy. This point has to be taken with some care because whilst it is an ordinary word, it's not being used descriptively. It's being used to have brand significance by EasyFundraising. So it's like, and we've got the registration. So the question is whether, in the light of our registration and their use as a brand, they're not just using it in descriptive language, then the question is, will there be confusion? Now, my learned friend's entitled to say it's an element with low distinctiveness, but it's not the whole mark. It is, however, the first part of the mark, and it's obviously, in spoken English, the most important part of the work of the mark, visually and orally. And that has to be given some weight in the analysis, visual, oral, and conceptual. That's fundamental. You have to compare the degree of similarity or identity between the goods and services. That's fundamental. These are all factors that have to be put into the list of things that ultimately decide infringement.
And that's what the judge did. The question is whether the judge was wrong.
Yeah, well, distinctiveness in my submission is a point that is overweighted in this case. You can infringe a mark of modest distinctive character, and it is not the end of the analysis to just refer to the distinctiveness aspects. The points. So, ground 5, yes. Ground 5, again on ground 5, there was my learned friend answered, you recall our complaint was that rather than focus on a notional and fair use of the mark, the judge looked at our actual use, and that was illegitimate. But my learned friend's answer to that was, it didn't matter because the judge's description at 257 of the judgment was coterminous with your trademark, which would be an attractive submission were it factually correct. It's not. So it's a very simple point. The judges, it just requires the court to have a look at 257, where he describes the difference between the EFL portal and he then describes Easy Life provides a website from which various products, including ones made by third parties, can be purchased directly from it. So when he's describing the EFL providing a portal, that is somehow regarded as not part of the trademark. But providing a portal is exactly within the specification because we don't look at variations. So ultimately, we don't look at the commercial reality. What we do is we look at the, as my learned friend colourfully put it, you've got the trademark specification in one hand, you're looking at the use, and so it's no answer to say, well, EasyGroup in fact doesn't provide a portal, whereas EasyFundraising does. It's just not the right approach. That's a fairly short point. Yeah. So yesterday there was a factual error made by my friend. Does my lord have the transcript from yesterday?
Not in court. It's been sent to us, but
so I'll just repeat it. If there's any question about it, I can. We can. It's page 152. Ms. Simsworth said that there was no infringement case against Easy UK. So this is at Easy UK. That was the infringing sign, and the trademark relied upon was Easy.com. Now that's obviously quite a close. It's at Easy UK and Easy.com as being the relevant comparison. And another friend said that there was no infringement case based on any of the marks at issue. We say she relied upon paragraph 228 of the judgment, which hopefully you'll have close to hand. And I think the issue was she was taking that particular paragraph. You see that one refers to, involves the same three marks, EasyJet, Easy Hotel and EasyGroup. And one would be forgiven for thinking that did not bring into play Easy.com. But that was because the judge had earlier not considered Easy.com because he'd revoked it for email services. Completely. So it just didn't, it was originally alleged, and we can see that earlier in the judgment. 191, yeah, paragraph 191. Easy.com was in play, but it wasn't by that point because some things the judge did consider on the alternative basis that he was wrong, and some he didn't. This was an example of where he didn't.
I'm sorry, when he refers there to various signs, I know the signs that are there referred to include the at Easy UK handle, do they?
Yes, so just, I'll just trace it through very quickly. So if you go to 191, the claimant alleges the first EasyJet mark, the Easy Hotel, and the EasyGroup mark, and the Easy.com mark, basically, were all infringed by EFL's use of the EF sign, the Easy Search sign, and the plain words. The next, sorry. But in view of my decisions on the revocation counterclaim, the claims based on the Easy.com.
I've got that point, but my question is about the ambit of the signs that were alleged to infringe.
The infringing signs as opposed to the marks relied upon.
Yeah, so.
My lord, this is of assistance. my learned friend is right. I think you can see it from paragraph 19 of the judgment.
Thank you.
Thank you.
And I apologise to the court.
Just then to pick that up then, obviously the comparison between easy fundraising and the various marks that are alleged is compared to Easy UK at Easy UK, social media handle now needs, if we're right on the email services, should be compared to that, is very, very close indeed. It's a social media handle for what? For a retail service of retail services. It's we say a closer comparison on the visual, oral, and conceptual similarity than the other marks, potentially the closest in the case. And also, those my submissions.
Thank you very much.
My lord, if I could address.
Well, just wait a minute.
Apologise.
So, Ms Simsworth, do you have anything on the cross appeal?
Just 2 minutes, if I may.
That's fine.
In relation to the points my learned friend made this morning on the cross appeal, he may well be right that it is sufficient, as he put it, to have retail services defined generally at the time of registration. But my lords will remember that I handed up a practice PAN 115 yesterday, which speaks in terms of the practice of the trademarks registry. And I would draw to my lord's attention, you may not want to go to it now.
So it's easier to do it while the point's in our mind. So, which paragraph?
So my lord will see that the practice amendment notice was issued as a result of the authorities that my learned friend has referred the court to. So that's the Nesto case and the Prakata case, our case. My lord will see, by way of the backgrounds that are set out, and then we get to the change of practice, and we see at paragraph 5 the distinction between the retailing of services and the provision of services per se. My lords will be familiar with the fact that we've had some talk about the bringing together type specification. If I could draw my lord's attention, it's halfway down the page under the I apologise, I may have got the page numbers wrong. One will see
Page 5.
I apologise, I haven't got a numbered version.
Now's the number page
My lords will see that there was a practice where users could file for retail services generally, but the registrar would encourage users to include.
Where are we looking?
I
Under
apologise.
paragraph 5.
So paragraph, I think it's at the end of paragraph 3. I apologise, my lords. You'll see how that we have the section on the bringing together, and in the last paragraph it says, whilst you can have retailing services generally.
I'm sorry.
I apologise.
I can't follow what you're referring to. If you could just give me a page,
Yes,
that would help.
I apologise. It's page 5.
Right.
And it's the last paragraph which says users should note that the examples presented in paragraph 8 above do not specify how or where the services are brought together. The registrar will not insist on the degree of a qualification to render such specifications acceptable. However, in the interests of ensuring maximum levels of clarity and precision, the registrar would encourage users to include such information in any applicant specification filed.
Right.
And my lord, what this is showing is that the registrar does accept that you can restrict to the way things are provided. So in retail store and the like. And in fact, in the specification that my lords are in fact considering in this case, which can be conveniently found in Schedule behind tab 7.1 of the core bundle at page 90.1. One can again see that there were, if I can put it this way, limitation. I mean, it uses the word including, but the type of limitations that we're talking about were in fact in the specification. It's specification. I apologise. It's left broader, but in the Easy Life marks, one can see that similar type restrictions were put in. So it's not uncommon to have the way the channel of trade, if I can put it like that, included within a specification, and that is recognised. So whilst you may start with the broad, they'll accept that. That's not at all to say that it can't and isn't acceptable to cut it back in the way that I suggested by way of my amended cross appeal. And unless my lords have got any further questions on that, that's all I would wish to say.
No, thank you very much. All right. Thank you all very much, and those behind you. And we should probably also, I should definitely include Mr. Edinburgh in that. So you'll pass that on to him. You'll be unsurprised to learn that we will not be handing down extempore judgments in an hour or so. We will reserve our judgments. They will be sent to you in draft in the usual way. That's so that you can comment on the typos and any obvious factual errors. It's not an opportunity to re-argue the case. That will be sent to you as a draft. The draft is confidential, as you all know, and therefore it's not to be provided to anybody who's not on the list that has already been compiled of those to receive the draft. And you will also know that it is provided to those others on the list for the purposes set out in the Counsel General of Wales case, and to go beyond that is a contempt of court. Once you've commented, and at the same time as you comment on the draft, we hope you'll be able to agree the terms of the order consequent upon our judgment. If you can, great. If you can't, maybe that there are 1 or 2 points between the parties on the draft orders. The best thing to do is then to produce a composite draft which has the alternatives in 2 different colours, and to provide short, and I mean short, written submissions as to why you're contending for the material in one colour as opposed to the material in the other colour. And then we will deal with those points and identify to you what the right order is, and then you can have that order drawn up. I can't at the moment say when you're likely to get those judgments, but you will obviously be notified in due course. Thank you all very much.
Court rise and